Namaskar. Very warm welcome once again to all of you. I am Satish Banot, running this YouTube channel dedicated to new school projects, school administration, and school operations. Currently, I am pondering upon the new amendments in the Principal Act, the Societies Registration Act 21 of 1860, brought out by Government of Punjab. The states do amend the Principal Act from time to time for the transparent governance in the affairs of society and accountability and ethical practices, etc. So, I have already covered up to the section 3, what amendments have been made to section 3 and what is required now. So, this video is going to be very beneficial, useful for all the officials who are handling the society affairs, especially who are handling the corporate affairs, secretarial practices, etc. So please subscribe this channel, follow or share it to the all those who you deem that these people are involved in society affairs, submission of returns, and conducting the annual general meeting or general meetings, so that necessary mandatory requirements are complied with. So now I will be explaining, I will try to explain to my best the changes made in section 4 under the new act, that is Societies Registration Amendment Act 2026 by Punjab government. Section 4 basically deals with the submission of list of society members with their addresses and occupation on annual basis. In the basic Principal Act, it is very in short. It is just to say that annual list has to be submitted with these informations. But now some changes have been made, and it has been made elaborated and more stringent. First of all, wherever in the act the word managing body was there, it has been replaced by managing body or the governing body. So there had been a confusion whether it should be called as a managing body or a governing body. It has been removed. So both the managing body or the governing body are the same. So the term managing body is replaced by managing body or governing body. Then again, one para has been added, provided that if the governing body, an educational or healthcare society, is elected after the last submission of the list of the members of the governing body shall be approved by a resolution passed at the annual general meeting by a simple majority of all the members of the registered educational healthcare society. So if there is a change in the list of somebody has been removed or somebody has been taken in, any change in the list of society has to be passed in the annual general meeting by the simple majority. More than half person should be in favor of the amendment or taking the person in or removing the person in. There may be many reasons. So unlike previous one, it was just list was made without passing the resolution. So now a meeting has to be conducted that should be in annual general meeting when new member is to be inducted or old member is to be removed, any change to effect any change in the list of members. Composition of the society means. Then 4A has been added. Every change made in the memorandum of the association or bylaws or rules of the education or healthcare society, it will be affected by a resolution passed by a two-third majority of the members at annual general meeting. So no person, secretary, president can amend the rules and send to the registrar during the filing of list. Now it has to be done during the annual general meeting, and the change in the memorandum of association or in the rules and regulation of the society, that is bylaws, are to be effected only when a resolution has been passed with a two-third majority. And intimation of such change, if change has been occurred, shall be sent to the registrar along with the annual list filing as required under section 4. So now main aspect is any change in the memorandum of association or in the rules and regulation must be passed by two-third majority, and such resolution has to be submitted at the time of filing the list of members when it is due annually. Then number 2 is if there is any change in the registered address for any reason, the registered office has to be shifted or relocated, then a certificate to this effect has to be submitted to the registrar with the annual list of filing, that is under section 4, and this certificate should be signed by at least 3 of the members of the governing body. So the first, when laws has to be amended, that it should be passed by the two-third majority. If any change in address is there, then the certificate has to be signed by at least not less than 3 of the members of the governing body. Unlike earlier, it was being sent by the president or the secretary. One person was signing and certifying that this change in address has been made. So now it is required to be signed by 3 members at least. Now coming to the very important point, It is very important, needs urgent intention also, because if any violation of this clause is done, it may have very adverse effect on the society affairs. Now, section 5, an additional section 5A has been inserted, which says, notwithstanding anything contained in any law, contract, or other instrument to the contrary, it shall not be lawful for the governing body of an educational or healthcare society registered under this Act or any of its member to transfer without the previous approval of the registrar any immovable property belonging to such society. So this is related to section 5 is related to the properties only. In original 5, section 5, any immovable or movable properties are to be vested in the name of society or trust. So there was not much restriction, but now every transfer made in contravention of subsection 1A 1 shall be void. So any property which will be transferred needs to be transferred to the other society or for any other reason must be done only after the approval of the registrar. So immovable property cannot be transferred without the approval of registrar. You have to write to registrar that this is property for this purpose we are transferring to this society or taking from other society. Whatever transfers are there, it should be with the prior approval of registrars of society. The expression transferred involves, it is not at all like sale. If you selling your property, for that obviously is to be for the society only. Their proceeds can only be spent for the same purpose, same objective. So expression transfer shall be for the purpose of section means any sale, any gift, or any exchange. It also covers lease for a term exceeding 5 years. If you say कि trend is there कि school has been or the institution has been given on lease for improvement or something, but if this lease is exceeding a term of 5 years, then an prior approval has to be taken, though it is not permanent transfer. Transfer of title, no ownership should be changed. In whatever name it is there, the properties in, if society wants to change the title, it should be with the prior approval of registrar. Irrecoverable license. If there are any irrecoverable license, that has also to be misuse of property का license होता है कि some institution has given license to use this property forever for on 99-year lease or something, that also license cannot be transferred. So gentlemen, these were the prominent changes in the section 5. So I am closing here at herself. Thank you very much. I will come with next section 12A in next video. Thank you so much. Thank you. Welcome all.